Hello, IP friends. Welcome to Hashtag IP series with your favorite podcast host, Rita Amory Chinda. Now, if you are a first time listener, you're welcome. I hope you find my podcast interesting. I hope you learn something new. And also, don't forget to subscribe and favorite my podcast so you don't miss out on any other juicy episodes. For my returning listeners, I just want to say I love you guys. I appreciate you guys. Don't forget to share your best episode with your friends and contacts. So what we do here is talk about recent trends and developments on copyright, trademark, patent, industrial design, trade secrets, geographical indication, and plant variety. And with that, I welcome you to today's episode. Stay tuned, guys. So, if I recall correctly, I had at some point mentioned that Nigeria now has a plant variety protection act, and one time I was scrolling LinkedIn. I was going through my LinkedIn feeds and I saw a post about a recent judgment in relation to plant variety. And I thought to myself, oh wow, why don't you um look at this from the Nigerian perspective, review the Nigerian law as well. So I had to, you know, go online and get a copy of the Nigerian plant protection plant variety protection act, and that's like 30 something pages. I had to print it out because I knew that having a soft copy would make it a bit difficult for me. But if I have a hard copy, it's easy for me to just refer to it, and that was exactly what I did. So, um, per tradition, we always have a case study that we like to work with. So our case study today is um, about a Nadorcott variety of mandarin tree. And this is a case between José Cánovas Pardo SL against Club de Variedades Vegetales Protegidas. So in short, it's CVVP. And they had some infringement issues in relation to the Nadorcott variety of mandarin tree. So I've always had this perception that plant variety or breeders' right is an unpopular form of intellectual property, especially within Africa, just like geographical indication. And last year, I know during the Christmas edition, I had a guest from UPOV, which is like the international body. For anything you want to know about plant varieties, just check out UPOV. So I had Hereta Hueta talk to us about plant variety, but then because we have these rights now, we have this act now in Nigeria. I decided to just analyze the case and also talk about our plant variety protection act. So I did come up with a poll and I asked people on Twitter if they knew that plants and seeds were eligible for intellectual property protection. Now, 53% said yes, 28% said no, while 19% said tell me more. It had a total of 32 votes. Then I went further to say, ask if they've heard about plant variety. 83% said yes, which I would assume they are IP lawyers or students or enthusiasts, while 17% said no. That had a total of 6 votes. But I would like to state that I'm proud that Nigeria took the step in creating this act. I mean, this is going to help rural farmers and also the country. We are so used to importing, and this is going to change the narrative about us importing crops and goods and seeds and the rest of it. So one of the objective of this act is that it helps to protect new varieties of plants and also promote increased staple crop productivity for smallholders farmers in Nigeria, and also um, encourage investment. I'm also excited about it because I am part Tiv. My mom is from Benue, so I'm part Benue and I'm part Rivers, Ikwe. And I know that the Benue State, generally known as the food basket of Nigeria, has different varieties of crops and plants, and everywhere in Nigeria too. So I think a couple of weeks ago, my mom had prepared yam for us. And when I tasted it, it was different from the regular yam that we usually buy and eat. And I had to ask her, where is this coming from? She was like, oh, this is from my place. And it's a very different special yam. And I was like, ooh. So imagine farmers within that region or any other part of Nigeria who are cultivating, you know, the different types of crops and plants. So for instance, water leaf. So you have the native water leaf and what's the other one? So all of those things need to be taken into consideration. So I'll just say a little bit about our story, and then make reference to the Nigerian the I'll make reference to the Nigerian um Plant Variety Protection Act. So this case is between, like I said, between José Cánovas Pardo and Club de Variedades Vegetales Protegidas. So I'll just in short say CVVP. And like I said, the dispute was about a Nadorcott variety of mandarin. So sometime in March 2011, CVVP sent a cease and desist letter to Jose to stop the cultivation of about 5,000 mandarin trees of the Nadorcott variety. 5,000. And now we know the importance of, or the need, or when you get to use a cease and desist letter is when you're trying to like caution an infringer, saying, hey, you, stop using my intellectual property. So um that's the role of cease and desist letter. Now the most interesting thing I found out about this case was that Jose had actually been cultivating since 2006 and had done about 4,457 cultivation, um, and he started doing that after the publication in the official gazette of the Community Plant Variety Office, which is like the European union agency responsible for implementing the system for protection of plant varieties. Whereas in Nigeria, Section 3 of the Plant Variety Protection Act provides that we have a plant variety protection office which will be domiciled in the National Agriculture Seeds Council, who will be responsible whose responsibility is to grant rights, that's breeders' right to facilitate transfer and licensing of breeders' rights, etc. So if you want to find out more about that, read Section 5 of the Nigerian Plant Variety Protection Act. Now, in this case, a community plant variety right was given in respect of the Nadorcott variety of mandarin tree um, sometime in October, so 4th of October 2004. Remember, I said Jose started cultivating in 2006. That is 2 years after um, this person got the community plant right. He started cultivating the mandarin trees. And before the application was launched officially in um, August 22nd, 1999. That's like, let's see, 1999 and 2006. That's about, let's see, 7 years, 7 years. Um, 7 years after the application was launched. So one thing to take note of is the dates. I mean, these are very important when it comes to intellectual property protection. And when you have like an infringement case and you need to like sort of defend yourself and prove your title, XYZ. Um, and then, so what we notice here is that in 2006, when he started cultivating, he was sued for cultivating before even February 15th, 2006. Crazy, right? I mean, now take note that there was a change in management between 2006 when Jose started cultivating and then sometime 2008. So in that 2006, Guest Leave, who had the I think it's pronounced Jess Leave. So it's spelled Gesliv. Apologies, guys. I'm really sorry. I know I should have done my research in terms of pronunciation, but um, he had gotten a community plant variety rights and also sent Jose a cease and desist. So it seems like Jose is like a serial infringer. That you always have to tell him, dude, stop infringing on my intellectual property. So if this was to be a Nigerian case, section 41 of sub 3 provides that where an assignment or any other transmission of a breeder's right is made, the assignee or recipient shall notify the registrar of the purpose of making changes, just for the purpose of making changes in the register. So basically, when management changed hand, the old management, which is just leave, should have informed the EU um, um, community plant variety office that he was handing over the management of the cultivation of Nadorcott mandarin to CVVP. But I'm not sure they did any of that. But again, um, just imagine two management had to send you a C and D. So I mean, when that happened the first time, I think your first point of call should have been, okay, let me reach out and you know have some conversation. Like we know, consent, permission, authorization is very important when it comes to IP. Um, and when Jose did not stop, the club, the Variedades, Vegetales, Protegidas sued Jose. Um, they took him to the Commercial Court of Spain for a declaration of infringement of his exclusive rights over the Nadorcott variety of mandarin tree as a preliminary measure. So it's also important to let you guys know that when someone infringes your work, you can't come out and say, oh, we don't have any enforcement, there are no laws, and can't be protected. There are remedies available to you to sue when you sue someone. And this was what the CVVP, that's the Club de Variedades Vegetales Protegidas did. Um they also sued for a declaration of infringement of their exclusive right over the Nadorcott variety from 15th February 2006 until the cessation of the cultivation. That means until when Jose stopped cultivating. They were also asking for an injunction to end Jose's unlawful cultivation, to remove and destroy any material of that variety in Jose's possession, and that he should pay compensation for cultivating that particular variety. Interesting, right? Now, let's hear what the court had to say. So, the Provincial Court of Murcia, Spain, held that Jose did not dispute, he did not argue with the fact that, oh, I was cultivating the mandarin variety illegally. He also did not even dispute the fact that he did not get consent from the owners of the plant variety. Um, so therefore, the court ordered him to pay 31,199 euros for the acts of infringement, and also as appropriate compensation for the acts performed without the consent of the holder of the community plant variety during the period of the provisional protection. Um, he appealed that decision, and the Supreme Court held as follows: that Article 96 of the Council Regulation number 2100/94 of 27 July 1994 on community plant variety rights must be interpreted to mean that, irrespective of the ongoing nature of an act of infringement of a protected variety, that the act of infringement of a protected variety or of the dates on which the act ended, the 3-year period of prescription set out in the provision in respect of claims pursuant to Article 94 and 95 of the regulation starts to run from the date on which the first community plant variety right was finally granted. So your term of duration start counting from the first they grant you your plant variety, your breeder's right. And second, the holder of the right had knowledge of the act and of the identity of that party liable. They also made reference to section Article 96, which is interpreted to mean that any claim pursuant to Article 94 or 95 of the regulation in respect of a set of acts of infringement of a protected variety brought after more than 3 years have elapsed at time barred only from when the first community plant variety right was finally granted. And so basically this particular article is saying that if you want to sue, you have to do that. um, if you're going to sue in respect of an act of infringement, it must be brought after more than 3 years have elapsed or expired. So if you're so I'm going to go into the terms of duration anyway. Terms of duration, say 20 years or 25 years. So 3 years after that you can sue the person for that. Then I did mention of provisional protection. I will talk about the Nigerian view in relation to that. So section 28 of the Nigerian Plant Variety Protection Act reads as follows: that the holders of a breeder's right shall be entitled to equitable remuneration from any person who during the period between when the publication of the application under section 23 was made and the date of the grant the act has carried out. Once the right is granted, requires that the breeder's authorization is provided for as stated in section 29. So the breeder's rights include, so it's kind of like similar to other exclusive rights granted to IP owners. So you have selling, the right to sell, um, production or reproduction, but in regards to this, I'm talking about conditioning for the purpose of propagation, offering for sale, exporting, importing, stocking for any purpose mentioned in paragraph A to F. Please check it out, guys. And then finally, the court also said that the right holder had knowledge of each individual act forming part of the set of acts and the identity of the party. So you must be aware of the infringement and also have details, identity. So you must know who the infringer really is. On days like this, I would like to say I'm proud to be a Nigerian because we have 70.8 million hectares of agricultural land area, with maize, cassava, guinea corn, yam, beans, millets, and rice, which are like the major crops that we, cultivate. Also, we have our President Mohamed Buhari has a policy on agriculture, and this act also is also very timely. So a combination of both the policy and the act is going to go a long way in helping rural farmers. Now, in order for you to enjoy your plant variety, your breeder's right, you must meet the basic requirements, which includes it must be novel, distinctive, uniform, and stable. Then the terms of duration is 20 years for trees, just like the mandarin tree, and then 25 years for vines. Vines as per VINES. Then also section 33 sub 2 provides that the holder of a breeder's right may sue an infringer by bringing them to court, which I assume in this case would be the Federal High Court. I mean, it wasn't even stated in the act. The act I went through all the pages and I didn't see anything. Even in interpretation section, did not have or specify the courts that will be hearing plant variety dispute. So I just want to assume that's going to be the Federal High Court because the Federal High Court has jurisdiction to hear intellectual property cases in Nigeria. Um, so, in wrapping up, these are my recommendation. Everyone, I believe everyone, including farmers, I'm sure familiarize themselves with the Plant Variety Protection Act of Nigeria. I know it's going to be difficult and tough for those in the rural area because of the understanding or having access to the law. So I'm proposing that we have like an awareness campaign in collaboration with the state government, the local government chairmen, um, village heads, so we sensitize everyone about the Plant Variety Act and then look for ways to commercialize and exploit um, the plants or the varieties that we have in each of our communities and states. Secondly, we need a research and development agency in agricultural sector by creating a registry of all the plants and seeds we have in Nigeria. So if we're going to actually develop or build or create new plants, let's have a facility that gives us the opportunity to experiment. I do recall a case that was told to us by Dr. Yog. He was my lecturer during my master's and in that case the case was about two farmers who shared a fence, and because of cross pollination, you know this other farm, let's say farmer B's variety or species had similarities, or you just developed or created a new variety or species of, I can't remember, I think it was maize, right? I think it was maize. I can't remember the case, but that also piqued my interest, and I got to think about it. I was like, oh, I mean, nature plays its own role, you get, and we really can't say much about it. But this other farmer A, was not having it, so they went to court. Can't remember how the matter was settled, but then it just shows you how intricate and fun and funny and upsetting and you know mind-blowing IPs such as plant varieties are just taken for granted here. I mean, we need to do a lot in terms of food is an issue. Um, Food scarcity is an issue. Right now, we're experiencing a lot of hike in prices in foodstuffs. Everything is just, I don't want to use the F word, but everything is expensive. Also, I'll be recommending that the public, farmers, and relevant stakeholders should be sensitized about plant variety as a form of intellectual property. I am upset because I did not hear that there was a plant variety bill. I didn't hear of any public hearing, so there was no room for people to actually contribute. I mean, we should have like strategies or timeline as to how to educate and make people be aware that, oh, this is actually coming out. um with like your contribution, what are your thoughts? So we have various languages in Nigeria. How do the rural farmer who still uses the crude or the old methods of farming know about it? How can the community benefit from this? How can the local government benefit from it? How can the state benefit from this? These are the issues. Just like every other form of IP, don't be like Jose in our case study and obtain permission to use any genre or species that are protected. How do you know if they are protected? You just do an application to the registrar or the plant variety office, and we get more details about it. Another thing is that to learn more about plant variety, you can check out the podcast version where I had Yolanda Huta, who is the legal counsel and director of training and assistance at UPOV. Now, the full meaning of UPOV is International Union for the Protection of New Varieties of Plants. It is an intergovernmental organization with headquarters in Geneva, Switzerland. Just like the World Intellectual Property Organization, you can go also into their um website to find out more about new varieties of crops and plants. I know um, Miss Yolanda had mentioned about a species of rose. I don't know. I watched some of this documentary when it crossed my timeline on Instagram or how they preserve rose. I think it was about Valentine, and they were, talking about how these roses are cultivated and then they are assessed and picked and purified and then sent to America because of Valentine. So they have process to check, oh, is this good, is this not good, and all that to know whether it's healthy, how long can they stay. So we need a whole lot. We need storage facilities, we need education, funding, we need equipment to help us prepare ourselves for this. I mean, in respect to the African Free Trade Continental Agreement, this is going to be a huge one. I mean, Africa as a continent is blessed. Nigeria as a country is also blessed. So imagine what would happen if every farmer, whether rural or urban, is informed, is educated. I mean, knowledge is power, to say the least. So you imagine what would happen if everyone and all hands are on deck. I know section I'm trying to remember, I think section 50. Bear with me, guys. So I think that particular section talks about funding, where the government will make provisions for funding, where they'll be able to fund trainings and the development of um, plant variety. So it's section 44. Section 44. Let me just read it for you guys and then we'll wrap up from here. I hope you guys learned something. I'm hoping to do a newsletter about it, but I don't know if I have the strength to do that. But so let me read section 44. So section 44 says the minister shall, after consultation with the minister responsible for finance, establish the Plant Breeders' Right Development Fund. In this act referred to as the funds into which money realized under this act shall be kept. Now the sources of money for the fund shall be fees payable under the Act, any donation or grant from the government or any other person. The fund shall be applied for development and promotion of the plant breeders' rights, training of plant breeders on matters concerning plant breeders' rights, establishment and maintenance of variety collection and database, and any other activities relating to administration of this act. I mean, this act is loaded and is not loaded. I have my reservation about certain things, but then this is a step in the right direction. I hope you guys learned something. I also hope that you found this particular episode interesting. Don't forget to make reference to the episode I talked about with Yolanda, which is, so for quick reference, that is episode that's season 1 episode 18, and that was published on the 25th of November 2020. So it's already a year. That particular episode is a year and 1 month today. But yeah, guys, I hope you enjoyed listening to me talk about this. If you have questions, if you want to collaborate, anything you want to talk about plant varieties, please reach out to me. I'm also learning about it, so I'm not like an expert, but I'm still learning on the job because I want to be better. um but yeah, bye guys, ciao, and see you in the next episode. Mwah.